We're on the record, State of Florida versus Stephan Sterns, 2024, CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Sterns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has case law provided a copy to the state already. I'm going to give you a moment to read, Judge, or you want me to start?
Just a moment. These highlight the McKay factors.
Essentially, Judge, they all essentially stand for the same
I'm
problem.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay v. State, first DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025, Westlaw 1119091 from last week from April of 2025. Trocola versus State, 867 Southern 2nd 129, 50 CA from 2004. And Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion, as well as in preparing the other case for trial. Defense is coming to information that at this time the defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of the homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would going to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Botham factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing the motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearings since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, a little 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of, to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense will be able to disclose that information even to the court, even if the ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of, the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed, discovery exhibits haven't been disclosed in regards to it, because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of a good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m. That will conclude our hearing.